This is Colin O'Keefe checking in for LXBN TV. In Already v. Nike, a case that went before the U.S. Supreme Court, Nike employed what some have called a sue and run tactic to enforce its trademark on Air Force One shoes. Joining me today to explain the case is Natalie Lederman of Sullivan and Worcester and their blog, Trending Trademarks. Natalie, first off, can you explain what exactly happened here? Why did the court rule the way it did?
Well, Nike sued to enforce its Force One trademark, a company called Already. They're a shoe manufacturer and designer, among other sporting goods. And they claimed that two of Already's shoe designs infringed their Air Force One mark. In response, Already filed a claim asking to have Nike's Air Force One mark invalidated. That was back in the summer of 2009, and after a few months, Nike decided it wanted to terminate the suit, leave the claim altogether. So it decided to issue a very broad covenant not to sue, in which it agreed that it would not go after Already for not just its previous and current shoe designs, but any future colorable imitations of those shoe designs going forward. So Nike also asked the court at that point to have its claims dismissed with prejudice and also to have Already's claims dismissed without prejudice, saying that at that point, having issued the broad covenant, Already's claims would have been moot. The parties appealed up to the Supreme Court, and the court decided that, in fact, Already's claim was moot. And they decided this because Nike's covenant not to sue was so incredibly broad that there was no way that this claim could possibly arise in the future. It was a very high standard for Nike to meet, and the court decided that Nike met that burden.
Very interesting. So do you see this practice, what Nike employed with the covenant not to sue after engaging in a suit, do you see this practice being employed by other trademark holders, or does it come with considerable risk?
Look, it's something now that, based on the decision, it's possible for trademark holders to use this tactic as a way to escape a lawsuit where there is a counterclaim that they'd like to get rid of, but it does certainly come with some considerable risks. What happened here is that because Nike issued such a broad covenant not to sue, it's saying that it won't issue any sort of claims against Already or any of its affiliates, going forward indefinitely on any, not just designs that exist now, but any colorable imitations into the future. So that creates a zone that Nike can't really enforce its mark within, not just the shoes that exist, but any designs that are colorable imitations. We don't know how broad that zone of colorable imitations will be, but it certainly will be a risk for trademark holders if they do seek to leave a suit the way that Nike did here.
Definitely kind of leaves that mark hanging out there in the wind, so to speak, with the covenant not to sue there on the imitation. So it'll be interesting to see, if anything comes of this afterwards. Again, that was Natalie Lederman, author on Trending Trademarks. Visit trendingtrademarks.com for more of her insight, especially on this case, and for curated commentary from the Lex Blog Network's thousands of authors, along with more video interviews. Visit us at lxbn.com. Thank you, Natalie.
Thanks very much.